Hello, good morning. So the material facts about this case is that the appellant Kesang Leasing Sdn Bhd entered into a hire purchase agreement with the first respondent for the hire of a computer. The second respondent provided a guarantee to indemnify the appellant against any loss from the first respondent's neglect or failure to perform the conditions of the agreement. The first respondent failed to keep up with his repayment schedule, and the appellant brought an action against both respondents. The learned magistrate dismissed the claim, holding that the transaction was not hire purchase transaction because the subject matter did not fall under the first schedule of the Hire Purchase Act 1967. The magistrate concluded that the HPA 1967 did not apply to the agreement. Thank you.
Assalamualaikum. This case concerns the application of the Hire Purchase Act 1967. The main legal issues was whether a hire purchase agreement for goods not listed in the first schedule of the Act, specifically a computer, could still be governed by the Act. The High Court allowed the appeal and entered judgment for the plaintiff. The court held that although Section 1, Subsection 2 limits the Act to certain goods, it does not prevent parties from voluntarily agreeing to be bound by the Act. In this case, the Hire Purchases Agreement expressly adopted the provision of the Hire Purchase Act and was drafted in the standard form used for scheduled goods. This clearly shows the parties' intention to apply the Act, and therefore the Act was applicable.
Assalamualaikum. For legal analysis of this case is important because it explains how the Hire Purchase Act 1967 works in Malaysia. Normally, the Act only applies to goods listed in the first schedule. However, the court said that parties can agree to include the Act of other goods, like computers. This does not happen automatically. Both parties must clearly agree to follow the Act. In short, the case shows that the protections of the Hire Purchase Act can be applied to more goods if the agreement is clear.
Assalamualaikum warahmatullahi wabarakatuh. So the importance of this case to business management is first to get Hire Purchase Act protection. We only receive its specific legal benefits if we explicitly say so in the contract. Second is to keep the contract valid. Without clarity, mixed rule can make the entire agreement enforceable in court. Third is to secure our strongest right. Silence could mean losing powerful Hire Purchase Act recovery options, leaving us with weaker standard remedies. Fourth, because it's not automatic. The Hire Purchase Act does not automatically cover system or non-scheduled goods. We must actively choose it. Fifth, the last one is it is essential risk management. One clear sentence prevent costly legal dispute and keep everyone aligned. In short, a simple line like this agreement is covered by the Hire Purchase Act secures our deal and avoid major risks. Thank you.
I will be presenting the critical evaluation for this case. The High Court seemed to come to the correct and reasonable decision. If the contract is drafted as a hire purchase agreement, and the contract has clauses similar to or use similar constructs to the hire purchase agreement, then it would be unfair to deny the owner the benefit of the calculation of debt merely because the property, which is the computer, was not a scheduled good. The judgment upholds the contractual principle of pacta sunt servanda, which means that contracts must be performed, and also the judgment pays respect towards the intention of the parties. Thank you.
Hi, I'm Trasin Pei, and I'm going to present about the fact of the case Norata bin Goyi and Jully bin Bandarang versus Hong Leong Berhad, which involved a hire purchase dispute. Norata as a first appellant and Jully as a guarantor are entered into a hire purchase agreement with Hong Leong Berhad to buy a second-hand Ford Laser for RM58,700 with 8% interest rate. And before signing the agreement, Norata has expressed that she was not agree with the interest rate and returned the car to the dealer. Despite of this, Hong Leong Bank still state that the hire purchase agreement was valid and claimed Norata was failed to pay the installment as promised, and sue her for the remaining balance after repose and selling the vehicle.
The big issue in this case is first whether the hire purchase is valid and enforceable when the vehicle was already written before signing. Second, whether there was any consideration to support the agreement since the vehicle was not in the hire possession when the agreement was executed. Third, whether the finance company could prove who made the deposit and who purchased the vehicle at the time of signing. The decision in this case is the Session Court made in judgment to support and agree with the finance company. So, the finance company won the case. Norata and Jully appealed to the High Court. The High Court held that was no valid consideration, and the final company failed to follow the Hire Purchase Act 1967. Therefore, the agreement was invalid and the appeal was allowed.
Assalamualaikum. So today I will talk about the application of legal principle under Section 2(1), the Hire of the Hire Purchase Act 1967. A valid hire purchase agreement requires that goods are let on hire with an option to purchase. In this case, although Norata initially received the car, she returned it before signing the hire purchase agreement due to disagreement over the interest rate. Therefore, at the time she agreed was executed, the car was not in her possession and there was no letting on hire under the agreement. Under Section 2D of the Contract Act 1950, consideration might exist at the time of contract formation. Since the finance company did not provide the car under the agreement, there was no valid consideration. Hence, the agreement was invalid and unenforceable.
Assalamualaikum. So I will explain about the critical evaluation for the case Norata Binti Goyi against Hong Leong Finance Berhad. So the High Court decision was fair and justified. This hire purchase agreement was invalid because there was no consideration, as the car had already been returned before the agreement was signed. This shows that the finance company failed to comply with the Hire Purchase Act 1967, especially regarding proper execution of the agreement. From a business perspective, this case highlights the importance of following legal procedure, maintaining proper documentation, and ensuring clear communication with customers. Failure to do so may result in contracts being unenforceable and cause legal and financial loss to the company.
Assalamualaikum. For the importance of the case for business management, for my part is the normal case. The first one was legal validity of the contract. This case showed that the contract cannot be enforced unless it met all the legal requirements. Even when a finance company is involved. The second one was essential element of hire purchase agreement. The court emphasized that a valid hire purchase agreement must include proper possession of the goods and valid consideration. The third one was compliance with the Hire Purchase Act in 1967. This case highlights that compliance in Hire Purchase Act 1967 is compulsory and cannot be ignored. Point 4 was risk of incomplete documentation. If key details as vehicle possession, deposit payment, or correct execution are not verified, the contract must be declared as void. The point 5 is managerial lesson. From a management perspective, strong internal controls, accurate documentation and proper verification is essential to avoid legal, financial and reputational risks. That's all for the importance of this case.